With several decisions, the European Court of Justice strengthens the rights of refugees in Europe. A judgment also has consequences for Germany. According to a judgment of the European Court of Justice, the famous ECJ, Germany violates EU law with its rules on the reunification of family members of refugees. The judges ruled on Monday in Luxembourg that family reunification should not be denied because a minor child has come of age during ongoing proceedings. The refugee organization Pro Asyl spoke of good news for families torn apart. That means a 180-degree turnaround for Germany. The background is two constellations. On the one hand, there are parents from Syria who applied for visas for family reunification with their underage son, who is recognized as a refugee in Germany. On the other hand, it is about the subsequent immigration of children. A minor Syrian woman wanted to go to her father, who was recognized as a refugee in Germany. As the minors became of legal age in the course of the proceedings, the German authorities rejected the applications for family reunification. An administrative court obliged the German authorities to issue visas for family reunification to those affected. But the Federal Republic appealed to the Federal Administrative Court, which appealed to the ECJ. So this directly came from Germany. This is clear in its judgment from Monday and thus confirmed a previous judge's decision from Luxembourg. The aim of the relevant EU rules is to promote family reunification and, in particular, to protect minors. The German approach is neither compatible with these goals nor with the requirements of the Charter of Fundamental Rights. According to the German rules, the competent authorities and courts would have no reason to process the parents' applications with the necessary urgency. In addition, the success of an application depends mainly on circumstances that are in the hands of national authorities and courts, in particular their speedy processing. The European Court of Justice also strengthened the rights of underage refugees who apply for international protection in Germany. The judges of the highest European Court ruled on Monday that an application must not matter whether the minor's parents have previously been granted international protection in another member state. The prerequisite, however, is that the minor has not previously asked for protection in writing in another country. In addition, no other EU state may be responsible for the test procedure under EU law. The background to the judgment is the case of a Russian minor whose application for international protection in Germany was rejected because her family had already received protection status in Poland. According to Germany, the Polish authorities were responsible for examining her application. The case will now be further negotiated before the Administrative Court in Cottbus. In another judgment, the ECJ also made it clear that underage refugees have a right to challenge the refusal of an EU country to admit them in certain cases. The background is the case of an Egyptian minor who initially applied for protection in Greece but wanted to contact his uncle in the Netherlands. The Dutch authorities initially rejected this. In addition, another decision caused a stir. Italian authorities are not allowed to inspect rescue ships like those of the German aid organization Sea-Watch in their ports without indications of a danger. This emerges from a decision of the European Court of Justice as well. The judges also ruled on Monday in Luxembourg that the EU rules on port state controls also apply to ships belonging to humanitarian organizations. For an inspection, the authorities would have to prove in detail that there are reliable indications of a risk to health, safety, working conditions on board, or the environment. The number of people on board alone, rescue ships often head for the ports with hundreds of refugees and migrants, is not in itself a reason for a review. The ECJ emphasized that there's an obligation under international law to help people in distress at sea. People who are on board after a rescue operation must be ignored in security checks. The number of people on board, even if it is well above the permitted number, cannot in itself constitute a reason that justifies an inspection, the ECJ said. However, after the rescued had disembarked, the port state was allowed to inspect the ship. When justifying such an inspection, it should also be taken into account that a ship certified as a cargo ship is systematically deployed as a rescue ship. However, only evidence of certificates that are also required in the flag state should be required. If an inspection reveals deficiencies, the port state may take measures that are appropriate, necessary, I already said appropriate. The verdict is great success for us, said a spokeswoman for Sea-Watch to the German press agency. Italy must now present concrete evidence for a port check. The organization said that the Mediterranean country had previously pointed out that the Sea-Watch ships were not certified as rescue ships in the right category. According to the organization, the German flag state does not provide for such a category for civilian ships at all. Sea rescuers complain again and again that the Italian authorities are holding their ships with quite flimsy justifications. The ECJ judgment on Monday concerned the ships Sea-Watch 3 and Sea-Watch 4 sailing under the German flag. They regularly go to the central Mediterranean to rescue people who have gotten into distress at sea while fleeing from North Africa towards the EU. And I'll see you in my next video. I'll be back.